People's Platform.
Good evening and welcome to the People's Platform. Does integrity in institutions exist? Let's find out. My guest tonight is President's Counsel Saliya Pieris. Good evening and welcome to the show, sir.
Good evening.
My first question to you. The President of the Republic has levelled a very serious allegation against you in Parliament, saying that in 2022, the Bar Association proposal to correct or rectify the then existing political crisis was to orchestrate your appointment as Prime Minister. What do you have to say about this?
Yes, I have already replied this, Sonali, on social media, and which was given publicity in the media. I say that it is an utter, absolute lie, and there is no truth in it, that the President of the Republic has used his immunity to lie about it, and that is totally wrong. The Bar Association proposals were prepared in April 2022. Together, it was prepared by the Executive Committee of the Bar Association, ratified by the Bar Council. On the day it was taken up at the Bar Council, there were a cross-section of the Bar was present, including those who are close to Mr. Wickramasinghe. I can mention them by name. They were present, and it was approved unanimously. Thereafter, the idea of that was to present, there was a crisis in the country, and we felt as professionals that we must present a set of proposals which could be worked out. Now, this was later on embraced by many other organizations, including the Ceylon Chamber of Commerce, and thereafter, it was presented to the political parties and also to the chief prelates. And there, when those proposals were presented, various political party leaders wanted to meet us. And in addition, the President of the country and the Prime Minister at that time also met the Bar Association. It was not me alone. The entire management committee, including the present Secretary of the Bar Association and the present Assistant Secretary, went for those meetings. Now, Mr. Ranil Wickramasinghe was heard to say in Parliament that he was unaware of these proposals. Now, I have the Hansard of the 4th of May 2022, and I would like to read that. There, first of all, the Minister, Honourable M.U.M. Ali Sabri, says this. I'll say it in Sinhala. Garu Kathanayakatumani, නීතිඥ සංගමයට ඉතා පැහැදිලිව කියා තිබෙනවා මාස 18ක කාලයකට පොදු ආණ්ඩුවකට යන්න මිනිමම් ප්‍රෝග්‍රෑම් එකකට එකතු වෙන්න මේ ප්‍රශ්න වලට විසඳුම හොයන්න ඊට පසුව සති 5ක බාරකාර ආණ්ඩුවක් යටතේ ඡන්දය තියලා මේ රටේ වැඩි දෙනාගේ කැමැත්ත විධායක ජනාධිපති ක්‍රමය අහෝසි කරලා පාර්ලිමේන්තු ක්‍රමයට යාමට නම් ඒක කරන්න කියලා ඒ යෝජනාව ඔවුන් ඉදිරිපත් කර තිබෙනවා. Now, once a minister, I think he was a minister of finance at that point, when he said that, Mr. Ranil Wickramasinghe replies, and he says, Garu Amathitumani, ඔබතුමා කිව්වා නීතිඥ සංගමේ යෝජනාව අරගන්න කියලා. මම ලැහැස්ති. ඒ වගේම ජෙෆ්රි අල්ගරත්න මැතිතුමා සහ අපේ කාලිංග ඉන්දතිස්ස මැතිතුමා ඇතුළු වෘත්තීය වේදීන් කීප දෙනෙකු කරුණු දක්වා තිබෙනවා. So, for now, the President to say that he was unaware of these proposals and to say that it was done with personal ambition is absolutely false, and I have replied that. And I've said that unlike politicians of his ilk, that I have not sacrificed my policies for the sake of any office.
All right. But during that time, there was also a discourse, a multi-pronged, multi-layered discourse between the SJP, the JVP, factions from the Aragale who wanted to bring in a non-partisan candidate to be the Prime Minister. Are you saying that you at no time had any intention of becoming PM?
Not at all. In fact, to become Prime Minister, you had to be a member of Parliament. And I had made it quite clear everywhere that I was not interested in any such move. And the whole purpose of us presenting these proposals was because we thought that it is our professional responsibility as a professional organization to come forward with a set of proposals, because the country was at a stalemate and that we thought there must be a way out of the economic crisis and the crisis of governance which existed.
All right, thank you for that response. Speaking of the integrity in governance and institutions, Mr. Pieris, let's talk about the debacle that is currently unfolding with regard to the Constitutional Council. The President of the country has claimed that the Constitutional Council is a part of the executive. He has said that he will appoint a parliamentary select committee to look into why the Constitutional Council is delaying appointments to high office. Speak to us about the constitutionality of these statements. There needs to be checks and balances between the three organs of government.
Yes, so actually if we see why the Constitutional Council was formed, was prior to the year 2000, there were these arbitrary appointments being made time to time by various presidents. And there were the appointments made to the Supreme Court, made to other institutions, were criticized. So then the 17th Amendment was enacted unanimously in Parliament, and the idea was that there has to be a check on the President's powers of appointment. Because the way Sri Lanka's constitution has been fashioned, the power is concentrated on the executive president. And he can almost do as he pleases. Now there are a few more checks, but still he has a lot of power. So even in selecting people for appointments to certain high post judges, Attorney General, Inspector General, Auditor General, Secretary General of Parliament, the President used to have there was no check on the President's powers. Then similarly to independent commissions. So the 17th Amendment was brought in, and I think Mr. Vikram Singh also, he was the leader of the opposition at that time, and this law was enacted where the Constitutional Council was established to act as a check on the President's powers. So at that time, the Constitutional Council consisted of 5 politicians, that is the President, the Prime Minister, Speaker and the leader of the opposition, 2 others, and 5 non-politicians who were distinguished persons from civil society. Now, that the Constitutional Council would have to approve the President's nominations. So whether it be a Supreme Court judge or the Inspector General of Police, so on. Then when it came to the certain commissions, the Constitutional Council would make recommendations to the President for appointments to those commissions. So that in that way, there was a tempering or a checking of the President's powers of appointment to ensure that the President would not arbitrarily appoint someone. So for instance, though the Constitution says the President can appoint a Supreme Court judge, the President cannot appoint anyone or should not appoint anyone whom he pleases. So for that reason, this check was brought in. Then came then as time goes on, Sonali, what happens is these executive presidents get power into their head, and they think they want to do, they know everything, and they think that their power should not be checked. So during the 17th Amendment also, somewhere in 2005, 2006, the Constitutional Council became defunct. Then there was a period of time there was no Constitutional Council, then ultimately it was scrapped by the 18th Amendment, replaced with a Parliamentary Council, which was a rubber stamp consisting of the Prime Minister, Leader of the Opposition and the Speaker and 2 other MPs. It was a mere rubber stamp who could only send observations to the President, and the President could take the observations and throw it into the wastepaper basket.
Sure.
Then that was found to be unsatisfactory. Then the 19th Amendment came, where Mr. Vikram Singh was the Prime Minister. Then in fact, during that time, the composition changed. There were 7 politicians to 3 non-politicians. But the first Constitutional Council under the 19th Amendment consisted of very distinguished persons from civil society. Dr. Ariyaratne, Mr. Shibli Aziz, Dr. Radhika Kumaraswamy. And we know that during that time, that certain attempts by the then President to make certain appointments, sometimes to the Judiciary, which were not suitable, were rejected by the Constitutional Council. And then when the particular name was rejected, the President came up with a different name.
Sure.
So there is this. So the President also understood that if the Constitutional Council rejects, his role is not to start bulldozing or bullying the Constitutional Council, but then to come up with another name. And this is what we call checks and balances. Then of course we came the 20th Amendment. Again we went back to the Parliamentary Council. Now we have the 21st Amendment enacted by the present regime. And now what we find is, because the President is unhappy with the Constitutional Council not approving his nomination, he thinks it is right to bully or bulldoze the Constitutional Council. That is totally wrong, because the whole purpose of the Constitutional Council was to act as a check and balance on the powers of the executive president. I know there is a debate whether the Constitutional Council is part of the executive or part of the legislature. We don't need to dwell on that. Yeah, the whole purpose of it was to have a check on the president's powers of appointment to the Supreme Court, to the Court of Appeal, the Attorney General. Now we know the Inspector General's post has fallen vacant. In the next hours maybe or days there will be a name submitted. So we need the executive president must respect the integrity of the Constitutional Council. He must have respect to that institution. The institution also, of course, certainly now I believe there are last week in Parliament there were certain rules tabled by on behalf of the Constitutional Council, which will be gazetted, and they will have to also follow a process which ought to be there. That was something lacking under the 19th Amendment. But for the President to try to say that he must have his way is, I think, reprehensible. And then you might as well not have the Constitutional Council. If a President of the country thinks that whoever he nominates, the Constitutional Council must, in my words, shut up and sit down, I don't think that is the way to go. And I do hope that the members of the Constitutional Council, both the politicians and non-politicians, will have the courage of their convictions and not get bullied by the executive president.
All right. On that note, we go in for a short commercial break. We'll be right back.
The People's Platform.
TV1. TV for life.
President removes Roshan Ranasinghe from all ministerial positions. Roshan Ranasinghe says his life is at risk, and if something were to happen, the President and Sagala are responsible. New Fortress LNG plant project abandoned. Sri Lanka opts to award the contract to China or India. Public sector protests demanding 20,000 rupee allowance.
TV1. TV for life.
The People's Platform.
Welcome back. We are in conversation with President's Counsel Saliya Pieris. Mr. Pieris, there is a dangerous trend where we see time and time again the legislature criticizing openly the judicial arm of government. We are seeing that in action with respect to the Sri Lanka cricket issue. We have seen it in the past, specifically with regard to the local government election issue. Speak to us about how dangerous this is, again, in line of the concept of having checks and balances between the three organs of government.
Yes, so for we must understand what the role of the judiciary is. The judiciary acts to protect the citizen from the state, especially from executive power, and of course resolving disputes between citizen and citizen. So that space which the judiciary has must be respected. If one does not agree with the decision of a judge, there is a process by which it can be appealed.
Sure.
So referring to judges in Parliament and attacking them by name, I think should be done only by what is called a substantive motion. But to refer to their to attack them personally is wrong. So, for instance, when in the local authorities elections cases, a three-judge bench of the Supreme Court issued an interim order, the next move was an attempt to raise a breach of privilege, issue of privilege of Parliament, and to threaten the judges with being hauled up before the Privileges Committee of Parliament. It was never done, but there was a threat given to the judiciary. Then we had another instance where the president of this country went to the Coconut Growers Association and he said, the government will not take orders from anyone relating to debt restructuring. Only Parliament has that power. In fact, the Parliament's power of public finance is in relation to laws passed by Parliament, not the subordinate legislation. But be that as it may, now the case is challenging the EPF to be held in the Supreme Court in a day's time. So the day before, the president went to the Coconut Growers Association and said the government will not obey any orders which are given. So what is the message which is given to the people and to the judiciary? So the judiciary's power to resolve disputes, to rule against a government in power must be respected, because that is, in a democracy, that is necessary. You need to have an independent and a strong judiciary which will act as a check on executive power. Of course, the judiciary also, we know that they act within limits. The judiciary cannot perform the powers of the executive. We do not expect the judiciary to be running the country. That is why the judiciary does not enact legislation, and very often the judiciary is careful not to usurp the powers of the legislature. But subject to that, it is important for the executive, especially the executive president, to respect the judiciary. And unfortunately, we have found that there is this trend of pushing back when the executive president is unhappy. And it is not only the present executive president, but over time we have had in 40 years under this constitution, 45 years under this constitution, we have had several attempts to impeach the Chief Justice, one which was successful. So that sort of pressure should not happen. On the other hand, I must also say this, it is also important, I think, and that is the important aspect of an independent and impartial judiciary, that there must be integrity in the judiciary. And part of independence and impartiality is that there must be an accountable judiciary. And certainly that too is a very important aspect. So in going forward, I think promoting in giving judicial appointments, in nominating judges, there must be a scheme which is formulated to ensure that those who are nominated are nominated not only on the basis of their seniority, but also to take into account their integrity, their efficiency, the manner in which how they have progressed. All those should be taken into account, and a holistic approach which is adopted. But the executive certainly must not unwarrantedly, unduly interfere in the judicial process, because that will send a wrong message. So that is why even when in Parliament, when there was an instance when, in reference to an ongoing case in a magistrate's court, the minister made some observations relating to the magistrate. So I believe that should not be permitted, and that is why, in fact, that is why the standing orders are there, and that is why matters which are sub judice, there is a restriction on discussion in Parliament.
If politicians continue to slander judges, obviously it's going to instill fear in judges themselves, and this can completely undermine judicial independence.
Yes. So I think whatever criticism has to be responsible criticism. In fact, I think there are judgments of the Supreme Court which have said that criticism can be done, but it must be responsible criticism. So we must understand that even a judgment can be criticized, an order can be reviewed, can be criticized, but you must do it in a responsible manner, not to attack not to launch personal attacks on judges concerned, but you can rationally, reasonably criticize a decision. And in fact, we know in many countries that happens, that the judicial decisions are reviewed, criticized. There is academic critiquing of judgments. We have had in our own country, for instance, I think Mr. H.L.D. Silva reviewed the Supreme Court decision relating to President Chandrika Bandaranaike Kumaratunga's second term, and he said it was wrong. So that is perfect. But personal attack on judges without any basis must be, and if there is a basis, there is a process. So of course that is why the Lawyers Collective in fact issued a statement and suggested that there must be a process developed, and there must be a judicial code of ethics which is promulgated, which would be good for the judiciary.
All right. Let's speak a bit about several of the proposed legislation that is in the public domain right now. The online safety bill, for example, a Supreme Court determination was given subsequent to 45 petitions that were filed. We have been told that the online safety bill will be subject to committee stage amendments. What is the guarantee, what's the assurance we have that these will in fact be done? And also the Supreme Court can only go into the constitutionality of a bill. Just because a bill is in line with the Constitution doesn't mean it's going to be suitable and best suited and in the best interest of the public of the country. Speak to us about your observations on that.
Yeah, so firstly, we have found the string of laws coming in. So the online safety bill is one. There is last week the cabinet had approved the
Broadcasting Regulatory
Authority bill. Then we have the prevention of the anti-terrorism bill. So all these are, if you take together, some of us call them the shut up laws, right? Because people are being told, just like sometimes parliamentarians and others, people are also being told shut up and sit down. When you shut up, you listen to what we have to say and you keep quiet. Now this is, I would say, these sort of laws are intolerable. So we must understand the limits of the court. The Supreme Court reviews bills for constitutionality, and just because a bill is held to be either constitutional or the Supreme Court makes various suggestions, it does not mean that is then everything is perfect. So for the classic example we have is of the 18th Amendment to the Constitution.
Right.
The 18th Amendment to the Constitution was challenged. A 5-judge bench of the Supreme Court said it could be passed. There were those who were challenging it said it required a referendum, but the Supreme Court said it could be passed with a 2/3 majority. But that doesn't make the 18th Amendment a good piece of legislation. So there can be the Supreme Court reviews for constitutionality, but laws for many other reasons can be bad and unwise. Now the Supreme Court might not look into the wisdom of a law. They will look at constitutionality, but the court might not say this is not wise to pass this, because the court might feel that is not the realm of the court.
Sure.
So on the online safety bill, the determination, I think in time to come we must do an academic review of the Supreme Court determination, and we must invite academics and maybe even from outside to look at the Supreme Court's determination in the light of submissions made and make observations. I think that would help all of us to develop the law. But we must understand that just merely because the Supreme Court reviews a bill, it does not make it a good law. But what is bad about the online safety bill is the way it seeks to curb freedom of expression, impose punishment on people, and trying to restrict the truth. No one has a monopoly on the truth.
Right.
I can't say I have a monopoly on the truth, or someone else cannot say, the president can't say he has a monopoly of the truth. The truth has to be determined when all the information is there. The truth will ultimately come out. But no, we can't have a commission appointed by the president telling all of us, you shut up, this is the truth. And that is intolerable, and it is dangerous, because this sort of law especially in Sri Lanka's climate. We know how Sri Lanka's laws have been misused. The ICCPR, the PTA, even the ordinary law of the land is sometimes misused by the police. So when you have special laws imposing excessive punishment, it is dangerous for democracy, it suppresses dissent, and we know how important in our country freedom of expression is. It is only if people have freedom of expression, you can expose corruption, you can expose inequalities. So for instance, we talk of various things which are happening relating to economic crimes, drug shortages, food shortages. What if freedom of expression was stifled? The public protests would not have happened if the freedom of expression was stifled. So we, the citizens of this country, must jealously guard their freedom of expression. But Sonali, I must also say this. Over time, the executive has attempted to stifle freedom of expression. In the 1970s, as a child, I remember Lake House being taken over. I remember the Davasa paper being sealed. I remember those days there were sometimes papers used to be published with large headlines in Sinhala Baladariya visin Kapaharin Ladi, censored. But ultimately people found ways of expressing themselves. So those who try to stifle freedom of expression through various bills will ultimately fail.
Okay. My final two questions for you. Do you think the legal fraternity has a greater role to play in actively challenging these issues where the executive is attempting continuously to suppress the freedoms of the public?
I do believe that there is a huge role cast upon the legal fraternity, because, and I think the public expect that from the legal fraternity. That was my experience in heading the bar. The public look up to members of the legal profession to protect their rights and to come forward to protect their rights, and I think that is vital because if we must remember that the courts are the last, shall we say, barrier or the safeguard which people have. So that for judges, for the judiciary to be strengthened, you need a strong and an independent legal profession which will strengthen the judiciary, and when the bar is strong, then that in turn the judiciary will be strong.
You were at the helm of the Bar Association of Sri Lanka during a very challenging time in the country's history, recent history. You are now a part of the Lawyers Collective. Is that a substitute to the Bar Association?
No, we are all members of the Bar Association. I am a member of the Executive Committee of the Bar Association. Certainly, it is not a substitute for the Bar Association, but it is a collective. Our goal, and it is not new either. It was there from the time of the impeachment of Dr. Shirani Bandaranayake. We have once again reactivated it.
Okay.
But we do believe, we have a common vision where we believe that the independence of the judiciary, the rule of law, and democracy are things worth fighting for, and which we believe that we are duty bound to do that. And for that purpose, we have got together. And hundreds of members of our profession have joined us in this quest to preserve the integrity of our democratic system.
All right, fantastic. Thank you very much, President's Counsel Saliya Pieris. Thank you for joining us on this edition of the People's Platform. Thank you for watching us. We'll be joined by Attorney at Law N.K. Ashokparan tomorrow to discuss the abolition of the executive presidency. So stay tuned for that. Good night.